Good afternoon, everybody. Welcome back. I hope you all had a great summer. I know it still feels like summer a little bit. I'm sure a lot of you, though, have sent your kids back to school. My name is Peter Neufeld. I'm a partner at Wagner Sidlowski. If you've been to these Lunch and Learn seminars before, I'm sure you recognized me by now. I'm the co-chair for this Lunch and Learn series on will challenges, along with Professor David Friedman. The subtopic that we're going to be speaking today about is mediation and will challenges. And although mediation is often mandatory in Toronto and a couple other jurisdictions in Ontario, it has, I would say, very significant import in the estates bar. Often will challenges settle at a mediation, and for good reason. And we're going to be talking about that today. An excellent article on this topic was prepared in advance of the seminar, and Maddie will be uploading or providing a link to that paper in the chat for this Zoom, so feel free to access that. We also have a really great template mediation agreement that Craig Vanderzee, who's one of the presenters today, has prepared. So thank you for doing that, Craig, and that also will be uploaded to the Zoom chat for you to download and to review during and after this presentation. And before we begin, as always, make sure you have your microphones muted at all times unless you are going to be asking questions at the end of the presentation. And after you're done asking that question, please again, remember just to mute yourself. Questions can be asked orally. Feel free to do that. You can also put a question in the chat and we'll be able to review that, and I can communicate that question to one or all of the presenters. Just as a note that this seminar is being recorded. So we have three presenters today. Usually we have two. Today we've got the benefit of having three. Craig Vanderzee will be joining us. He's a partner at Torkin Maines LLP in their trusts and estates litigation group, and he is certified by the Law Society of Ontario as a specialist in estates and trust law. He's known as one of the estate bar's top mediators. Aside from mediation, Craig's practice includes all aspects of estate trust capacity, fiduciary, and power of attorney disputes, consisting of individuals, trust companies, government agencies, and other organizations. He'll be joined by David Wagner and James Dunphy. David is a partner at Wagner Sidlowski. He practices exclusively in commercial and estate litigation. And in the context of estate litigation, David is routinely involved in will challenges and executor accounting disputes. So a real breadth of knowledge there. He'll be joined, of course, with James Dunphy, who is also a partner at Wagner Sidlowski. He started off as a criminal defense lawyer in Ireland, but now practices in estate litigation and commercial litigation at Wagner Sidlowski. He's also a former member at large of the Advocate Society of Estates and Trusts practice group. A big thank you, as always, to our sponsors, the B'nai B'rith, Concentra Trust, Scotia Wealth Management, Torkin Maines, TD, and BMO Trusts and Estates. This event is complimentary because of them. We couldn't have done it without them, so thank you all very much. If you have enjoyed this seminar to date and enjoyed this particular episode, we ask that you consider making a donation to the B'nai B'rith Canada Food Program if you haven't already. And Maddie will be including a link for that in the Zoom chat. So please don't hesitate. We really encourage you to make a donation to the B'nai B'rith. On that note, we have Richard Robertson here today. Richard's a research manager at the B'nai B'rith Canada. He's here to discuss a bit about the charitable work that the organization does. So Richard, go ahead and take it away.
Thank you very much, Peter. Just for those who don't know, B'nai B'rith is Canada's most senior human rights group. Our mandate is to aid the grassroots Jewish community here in Canada, but also to combat anti-Semitism as well as all forms of racism and hatred in this country. I'd like to thank you all for allowing us to share a bit about what we have been doing here at B'nai B'rith Canada. Our focus has shifted to fall. The weather hasn't shifted yet, but our focus certainly has. In our CARES department, we continue to support the seniors in our community. Seniors are a large part of our CARES mandate. We want to give them as meaningful a fall as possible. We are doing this by providing them fall-themed activities. We will be taking them apple picking, as well as organizing a bird watching for the local seniors in our community, as well as recently last week, we had a herd of pygmy goats come to provide some much needed therapy to the seniors in our office. Goat therapy is a thing, people. It's fantastic. On the advocacy front, which is more my bread and butter, fall means the return to Parliament. And what that means is B'nai B'rith will continue its work on the upcoming online harms legislation. Unfortunately, the scope of the upcoming online harms legislation that we hope will be passed this fall will be restricted solely to regulating social media companies when it comes to their influence on the proliferation of what we have termed online harms in this country. For us at B'nai B'rith, that's not good enough. All of those who aid and abet in the dissemination or proliferation of harm online and profit from their participation in Canada's online realm must be held accountable. And this includes online retailers. Recently at B'nai B'rith, we've seen a gross uptake in the amount of anti-Semitic, racist, and generally hateful materials available for sale online. And so we'll be focusing our fall advocacy efforts in ensuring that any future legislation, any future commitments from the federal government to tackle online harms includes online retailers, as this is what we've identified as a sore spot in the current legislation. As Peter noted, your series couldn't exist without B'nai B'rith, but B'nai B'rith can't exist without the generosity of the public. So if you do like what you've heard today, or you do believe in assisting us in making our country a better place, then please do feel free to utilize the link provided to help support our initiatives. And thank you very much for your time.
Awesome, Richard. Thank you so much for that. We're going to start off with the substance of the seminar now. I believe James Dunphy is going to start us off. So James, take it away.
Great. Thank you very much, Peter. And I'd just like to start today by talking about some of the logistics for mediation. And one of the primary logistical ideas that parties will need to consider is whether or not it should be in person or virtual. And it's hard to believe now, but in April 19th of 2022, the guidelines to determine mode of proceedings in civil proceedings stated that mandatory mediation must be in person unless consented to virtually. And, you know, there are advantages and disadvantages to both modes. You know, virtual mediation, it likely leads to lower costs. For instance, there's no travel costs. There's no need to book a venue. Generally, venues that you would need to book would contain, you know, at least 3 rooms, one for each of the parties, if there are 2 parties, and a third room for the mediator. And those costs can add up. Also, the benefit of a virtual mediation is mediations often run late. And when they do, you and your client, you're in the comfort of your own home. So when it's sometimes 10 p.m. or even later, midnight, when you're finalizing those minutes of settlement, it is nice to be in the comfort of your own home rather than a downtown office. But, you know, a lot of lawyers are increasingly finding that in-person mediations are better. And some of the advantages of in-person mediations are it gives a greater sense of occasion. You know, clients, they're forced to dress appropriately, leave their home, attend a formal office environment, and meet their lawyer and the mediator in person. And the result of that is that the mediation, it gets the client's full attention. You know, mediations that are happening in home environments, they contain distractions which are both big and small. But when it's in person, you get to speak with the mediator. You cannot hide behind a screen. And it's important for lawyers to consider whether or not their client would benefit from having to rationalize their position in person both to their lawyer or to the mediator. And, you know, as a concluding thought, if costs are the only factor which are determining whether or not to do it virtually or in person, and sometimes it is, clients should be reminded that, you know, if the matter does not settle, costs of trial will greatly exceed whatever the difference in cost is between a virtual or an in-person mediation. Another one of the logistical ideas to consider is who to choose as the mediator. And there are two options. One is to hire a private mediator, and the other is to hire a roster mediator. Now, by far and away, the most popular method is choosing, or certainly in the estates bar, is choosing a private mediator. And this is typically a very knowledgeable estates and trust litigator. They're experienced, well respected in the field. And one of the panelists today, Craig Vanderzee, is certainly one of those mediators that I would include in that panel. I've used Craig before, and he's very effective. But one of the considerations that lawyers must turn their mind to is what style of mediator would best assist in the settlement of the dispute. You know, some mediators are more likely to press the parties on their position and will more freely give their opinion on the strengths and weaknesses of their case, and sometimes the other party's case. So which type of mediator would best facilitate a productive mediation, knowing the client that you have? And that's something that, you know, all lawyers should turn their mind to, you know, before putting a mediator in the order of giving directions, or before having that conversation with opposing counsel. And in my experience, private mediators are very effective. I'd be interested to hear from Craig as to how effective mediations are. Craig, are you able to share what percentage of mediations you've been involved in that have settled?
Well, I would say a significant majority. There would be years when 80 to 85% settle, but it just depends on the nature of the cases that are coming in. And I can chat about, when I'm speaking about commonalities in some cases that do not succeed at mediation, as to what they are, because they're typically common threads of issues that arise. But yeah, it's a significant majority that would settle, but there's always going to be several that don't settle for different reasons.
Great. Yeah, and I think that would correlate with my own experience. Certainly the greater share of cases that I brought to mediation have settled, but that's helpful to hear from an experienced mediator's perspective. So, I mean, I've mentioned that there are two options for choosing a mediator, private and roster. I've never used a roster mediator for an estates matter. I have for other civil proceedings, but that option is available, and people should know about it. And if you look up the Ontario Mandatory Mediation Program page of the Ministry of the Attorney General website, you can find a list of mediators who, some or all of which will do estates related disputes. And when we're talking about logistics, you know, one of the big questions is, when do we go to mediation? And the rule is that it must be done before the hearing of the dispute by a judge. But practically speaking, it should not occur until the parties know the size of the estate, you know, what assets are in dispute, and that they have reasonable valuations for those assets. You know, without that information, I think proceeding to settlement would be unwise. And if you're at a settlement where parties aren't sure of the numbers, it can make settlement very challenging. Again, logistically, lawyers in in every case will ask themselves the question, do I do mediation before discoveries, or do I wait until after? And, in will challenge litigation, the named executor is often also the attorney for property. So the question of whether or not a formal or an informal accounting should be provided would be an issue. Also, whether there's a statement of assets and liabilities, and the whether or not the accounting and the statement of assets are deficient. And if there are any allegations of missing money, and if those allegations cannot be cured through dialogue between counsel or orders for directions, then the parties may have no choice but to proceed to discoveries before mediation. Again, otherwise, no one will know the size of the estate, what everybody's actually fighting about, and it makes settlement very difficult. There is another consideration when dependent support claims are wrapped up in the will challenge litigation. And a dependent support claim can come from the propounder of the will, or it can also come from the other side. And with a Part 5 claim under the Succession or Reform Act, it often makes sense to test the applicant's case and discoveries prior to mediation. And the reason for that is there are over 20 factors that a court will look at when deciding whether or not to make an award. And those factors are set out at Section 62 of the Succession or Reform Act. And, parties often don't have answers to a good chunk of those factors. And in order to properly advise your client, the alleged dependent, on the strengths or weaknesses of their case, or indeed the other side, it makes sense to ask those questions first. And obviously, that will either undercut the dependent support claim, which might induce flexibility in the applicant, or substantiating it might induce compromise from the other side. So those are my thoughts for now. And with that, Peter, I'll hand over to my colleague, David Wagner.
Thanks, James. I don't think I can stress enough how important the logistics that James talked about are. They can really influence and impact whether or not a mediation is going to result in a settlement. Choosing the right mediator, the right venue, all of that is critical. And I think James did a great job at articulating some of the things and some of the major factors that should be considered. But what I'm going to talk about is a little bit different. It's after all those logistical or preliminary issues are taken care of and the mediation has been scheduled. How do we prepare for the mediation to be most effective for our clients and to hopefully result in a resolution? The first step that I take is preparing the mediation brief. And to me, investing in the mediation brief, spending a lot of time and effort in drafting a mediation brief is something that some people I find undervalue, and it can be critical to not just negotiating and resolving the matter, but also to getting a good resolution for your client, or a better resolution than you might otherwise get for your client. And I like to think of the mediation brief from first understanding what the purpose of it is. And from my perspective, and people may disagree with this, but from my perspective, I like to think of the purpose of a mediation brief as being a document, an advocacy document that is intended to convince the mediator of your position, not the opposing counsel and not the opposing party, but the mediator. I think when you get to a mediation, you have a very small likelihood of convincing the opposing party that your case is right and their case is wrong. But I do think that you have a strong likelihood of being able to convince or persuade the mediator towards your position. And that can be really important, because what I found is that when you go to mediation, the mediator comes into the mediation with a preconceived idea of what a fair outcome would be. And then what they do is they push the parties towards their idea of what that fair outcome is. And it may be subconscious, it may be conscious. There are certainly mediators out there who take the position that their job is not to get a fair resolution, but just to get a resolution. and they don't care whether it's fair or not fair. And that may be true, but still the preconceived idea of what a fair outcome is going to be guiding who they push, where they push that person, and how strongly they push one party or the other. So convincing the mediator can have a huge benefit and can impact the way the mediation actually proceeds. So what does that involve? How do we draft a convincing or persuasive mediation brief? I actually like to start with the law section. I like to make sure that I know the law, I know the cases, because you can expect to be challenged on every point of law that you make. And if you don't have the case law to back it up, the mediator will take advantage of that and challenge you on it and say, no, the law says this, or that case is distinguishable because of this reason. So you have to not just find the principle, you have to know the cases that you're relying on. And you have to know the facts. You have to understand why your case is analogous to the case law that you're citing. You have to know why it's distinguishable from the case law that the opposing party is citing, and you have to know all of the facts so that you can respond again to challenges from the mediator. But you especially have to know, and James touched on this, what the assets, and more importantly than the assets, what the net value of the estate is. You have to know what the issues are, what you can claim, what is in dispute. And knowing that puts you in a good position to not only make the arguments, but also puts the mediator in a good position to understand what's at issue. So once I've drafted the mediation brief, and sorry, just to finish the thought, once I've drafted the law section, then I'll go back and I'll make sure that the facts section has all the facts that I'm relying on, that I've cited all the facts to the documents that are important and critical documents, and all of those have been included. And then once I've done all of that, that's when I draft the overview section. Now that's the stylistic thing. Some people may differ in how they approach things, but that's what works for me. So once I've drafted the mediation brief, or at least put significant effort into drafting the mediation brief, I'll look at the estate generally and identify and address any potential tax issues. There's, as James touched on and I touched on earlier, what we really want to know is what the net value of the estate is. And in order to know what the net value of the estate is, we have to know what all the assets are and what all the liabilities are. Have tax returns been filed? If they have they been filed correctly? But even more than that, there are certainly opportunities in some circumstances where there could be certain tax planning, postmortem tax planning steps that can reduce liabilities and thereby increase the net value of the estate, making the pie bigger for people to split. Alternatively, there may be tax efficiencies in the way that you structure the settlement, which again, you're really after what your client is going to get on a net basis. It doesn't matter what they get on a gross basis. So if you could structure things in a tax efficient way, you want to have that information beforehand. On the flip side, you can have negative tax implications if you structure things in the wrong way. Peter Weissman at Kadesky wrote a good paper on dealing with some of these tax issues that litigators should be aware of when they're going into mediations or they're discussing resolutions. And I highly recommend that paper. Peter's very qualified and someone who has a lot of experience in dealing with these types of issues. So identifying those issues in advance are really important, because you don't want your client walking away with, let's say, for example, it's a $1 million fight and your client thinks that they're getting 50%. So they say, I'm going to walk away with $500,000. But then at the end of the day, after tax, they only get $350,000. Well, now you have a disappointed client, even though they got 50% of the estate, because they thought that they were getting more money than they ended up with. That brings me to the third step, and that's having a discussion with the client. Managing client expectations is really, really important, because the worst thing that I've experienced coming out of mediation is getting a really good settlement and having a disappointed client. So to manage those expectations, you want to have a discussion with your client in advance of going into the mediation, not at the mediation itself, but in advance of the mediation. And that is really critical, and I'll get back to that in a second. But when I have that discussion with the client, I talk about different settlement categories, potential settlement categories. And for the sake of this conversation and this discussion, I think it's helpful just to think about it in terms of, dollar amounts, but obviously there's nuance in every settlement discussion and every single case, but it's just helpful to think about it in terms of dollar values. But the first category that I speak to them about is a settlement that I would try to talk them out of accepting. I would tell them that it's not a good idea to accept it. Now, obviously, it's their decision what to do, what not to do. If they choose to accept it, I'm going to advocate on their behalf to the best of my abilities. But it's a settlement where I think that it undervalues their claims so much so that I would try and talk them out of it. The second category that I break down the potential settlements into is a settlement that's okay. It's not great. It's not bad. They want to take it. I'm not going to try and talk them out of it, but I'm also not going to try and talk them into it. And that's where, frankly, most mediations will end up, in that middle category. But the third category is a settlement that I think is so good, based on the merits of their claim, based on the evidence that there is in favor of their claim, based on the evidence that there is against them, the risks of going to trial, the costs of going to trial. But it's such a good settlement proposal that they should be so excited by it that they should not only pay our fees in full, but they should buy me a bottle of scotch. And I'm going to try and convince them to take it. And not only that, but maybe I'll even, if they don't want to take it, I'm going to send them an email afterwards saying, I recommended that you take this, and against my advice, you declined. And dividing it into those three categories, for me at least, has been a really helpful way for clients to understand the different sort of categories of potential settlement options. It's something that I've found clients have been able to relate to, more so than talking about specific dollar amounts. But when I have that conversation with clients in advance of mediation, I make sure that I'm taking notes, good notes, and I send them a reporting letter. And before I tell you why, let me just talk about another question that I asked. And usually I'll ask this question prior to talking about what I think about their case. I'll ask them what they think, or what they expect to get out of the mediation, or what they'd be happy getting out of the mediation. And I ask that question first because I want to know whether their expectations are realistic to begin with, either on the high end, low end, if they're unrealistic, but I want to know what they're thinking and what they want to get out of it. Because sometimes it's not just about the money, sometimes it's about grandma's tea set, sometimes it's about the principle of things. So it's very helpful to have an idea of what your client's goals actually are. Getting back to that reporting letter, I like to send something in writing to the client, talking about what they said that they expected to get out of mediation, what I thought was realistic. Because what I've experienced on occasion is that I'll talk to a client and I'll say, what do you expect to get out of mediation? And they say, I'd be happy with $1 million. In fact, I'd be overjoyed with $1 million. And then we get to the mediation and it's 11 o'clock in the morning, and I've somehow managed to get the other side to offer us $1.5 million. And of course, the client wants more, even though they said before they'd be happy, overjoyed with $1 million. And we'll get to the point where it's 5, 6 o'clock in the evening, and we've gotten the other side up to $2 million, and the client won't take it. And they're saying, I'm willing to walk away. The adrenaline from mediation can really impact clients' expectations, and it can sort of create these moving goalposts. I like to have that reporting letter out there because I'll pull it out at that point and I'll say, you want to reject it? That's great. But remember, before any of this happened, before we spoke, you said you wanted $1 million. You have $2 million on the table. Are you really willing to risk that? Are you really willing to walk away from that? And I think it helps ground people because it takes them back to a time where they were less emotionally driven and less driven by the emotions of the day, when they were thinking about it in a little bit more of a detached way. And it helps them sort of appreciate the settlement offer that's on the table. So the fourth step that I take in preparing for mediation, and this is something that I learned from my father, from Charles, that I hated doing at the beginning of my career, but it's something that I've really grown into and I've seen the value of as I've continued and done mediations on my own. But it's preparing settlement documents in advance. And there's a limit to what you can do here, but preparing minutes of settlement to the extent that you can, preparing releases, any anticipated draft orders that you're going to need in advance of the mediation has been a really, really useful tool. What I found is that, especially if it's a hard fought mediation, it's finishing at 8, 9 o'clock at night, you might get the minutes of settlement together, and it will include a provision that says something along the lines of release to be agreed upon by the parties with counsel acting reasonably, or draft orders to be included or to be agreed upon by counsel acting reasonably. And then you have two difficulties. Sometimes there are issues that come up. For example, in a release, is it supposed to include a confidentiality provision? Is it not supposed to include a confidentiality provision? Or in draft orders, certain provisions may be agreed upon, not agreed upon. But even more basic than that, I've had a real difficult time, and I won't name names, but I've had a real difficult time on occasion getting counsel and the opposing party to deal with the release or deal with the draft orders in a timely manner. Once the matter is settled in principle, getting the other side to dot all the I's, cross the T's, tie up loose ends can be a real difficult, timely process. It can add expense. So you want to end the mediation, if you have a resolution, with as much of that taken care of as possible. It's not always possible to take care of everything, but to the extent that you can, you want to get all your documents in order and all your documents drafted. So that's sort of my process of how I prepare for a mediation. And I think Craig's going to speak next, and Craig is going to talk about mediation from the perspective of the mediator. I urge you all to listen, because he's the most important person who's going to speak here today, because his perspective is really what you want to hear. What works at mediation, what doesn't.
Thank you, David. I'm not so sure that I'm the most important one speaking today, but I do think it's important to understand a perspective from a mediator. So I'm going to talk about a couple of different things. And the first thing that I think is really important is for the parties to decide how they want the mediation to proceed. Do they want it to be in person? Do they want it to be by Zoom? And then what I'm finding is becoming, I don't know if I would say popular, but certainly I've done a number of them in the last year. It's what I call a hybrid. It's both in person and by Zoom. And that's because not everybody can attend, but most can. And the most that want to, most of the people who are attending are the ones that do feel. So say, for example, there's 3 parties. All the counsel want to be there, and they can have one of their respective clients there, but one of the other respective clients, or maybe a spouse or an adult child who their client wants as support, can't be because they're working. And so they can only participate for, an hour during the day, in the morning or at night, or in the afternoon, or towards end of day. So I've done a number of mediations which are hybrid. So a Zoom invitation goes out to everybody. If it was being held at my office, all counsel would have laptops, including me. And I would start the day with my preliminary comments on Zoom to everybody. And then when it was time for me to go into one of the parties' respective rooms, I would just simply go in person to the conference room. If I'm dealing with a counsel who is in Kingston or Ottawa in what can't make it in, but they're only one of the 3 parties, then I deal with them by Zoom. I can still have a council meeting at end of day once it's been settled, and we go over the terms of settlement on the Zoom itself. And so that's what I call hybrid, where it's not just in person, it's not just by way of Zoom, it's a hybrid of both. And that can be very successful depending on where people are located. I had one where a spouse was on a trip on the West Coast, and it was sort of, I wouldn't say impromptu trip, but something at the last moment, so they couldn't attend. So we made their participation by Zoom. We didn't have to reschedule the mediation because of that. So think of that. Also, I am finding, quite accidentally, that sometimes when you have an in-person mediation or even a Zoom mediation, that people are moving around towards end of day because they've got to pick up kids or they have to get home for some reason. Just bear in mind, if your client needs to do that, I do have it where someone will have little kids and they say, I need to go pick up the kids. The ride fell through for the kids. Okay. So if the council tell me that, they'll leave, they'll go away for a half an hour, pick up the kids, I'll deal with the other party, and then I'll get back to them when they're there. So I've had lawyers tell me at 6 o'clock, Craig, can you deal with the other room right now? I've got to scoot home to get home, and I'll join back in at 7. These are all things in the new world, what I call the post-COVID world, that are in play. So think about the manner in which you want to proceed. Think a little bit about the mediation agreement. A sample one, a sanitized version of an agreement to mediate that I use has been provided. So, please feel free to take a look at that. I'm just going to point to a couple of things in the agreement. One is confidentiality provision, and that is paragraph 8 in the agreement. While all counsel would know that what is said and done and discussed at the mediation is confidential, someone's spouse or someone's adult child doesn't necessarily know that. They may not read the agreement. So in any mediation that I'm doing, I ask the parties who is going to attend. Because with Zoom, you can have the pop-in guest. You could have a lawyer at their house, you could have their client at their house, and all of a sudden someone pops into the screen who's going to assist them for the day, and that's a surprise even to the lawyer. It could be an adult child, it could be a sister or brother, it could be a spouse. Everybody signs the agreement to mediate, because while counsel may have told their client it's confidential, you want the non-party who may be participating with everybody's knowledge and consent, such as a spouse, such as an adult child, such as a neighbor maybe providing support to an elderly person, to sign the agreement to mediate. So you need to appreciate who is going to be involved in this mediation. And that change is very different, or it's very different with Zoom than it is in person. You're not going to typically have midday someone popping in to a mediation that's in person. It can happen, and it does happen in Zoom, sometimes inadvertently, but they have to sign the agreement to mediate. The other aspect is the default provision regarding information that a mediator hears. You're going to want to know what is the mediator's default policy about discussions you're having with the mediator in your breakout room. In the agreement to mediate that I provided you with, my default is that anything that I hear in a room, I'm at liberty to use in the other room unless counsel asks me not to. Okay, and that happens all the time. When I'm counsel, I might say to the mediator, I'd like you to know this, but don't tell the other side yet. We'll let you know about that. Sometimes it's an issue of legal costs, and you don't want the other side to know what the legal costs are, but you want the mediator to know because it could be a factor. When I hear that as a mediator and they put a caveat on what I can tell the other side, I draw no inference, and I make no inference about that. That's just a strategy decision, and I do it when I'm counsel and I'm not the mediator. But it's something to understand when you're at the beginning of the mediation, what the mediator is going to do in that regard. Think about your settlement scenarios before the mediation, not at the mediation. David touched upon that. You want to go over with your client, if there's $1 million at stake, what will be your anticipated progression of offers? Now, that doesn't mean you're going to tell the mediator that at the beginning of the day. That's going to be confidential to you and your client. But it strikes me sometimes when a lawyer and a client are talking for the first time about settlement, and it's at the mediation, and it's quite clear it's the first time they're talking about it. You want to know it to the extent you can. You don't know what the other side's going to offer, but you can start to plan what your laddered offers might look like, so that when you get to the end of the regular day for a mediation, which ends at 5, they often typically go quite a bit past 5, but that's when both sides have started to come towards one another sometimes, and there is a stress factor. And it goes to what David was talking about understanding what the client's expectations are. You really don't want to find out what your client's expectations are at 6 o'clock or 5 o'clock during the mediation. You'd like to have that planned out. To the extent you can, you don't know what the other side's going to do. And the other thing is, when making offers, is think about what your first offer is going to be coming into the mediation. I can tell you that it has been on more than one occasion, in fact, on a number of occasions, where the first offer that one side gives to me to provide to the other side is actually an offer they can't even achieve at trial. And it's not about crafting a resolution somewhere in between the two sides. Is if they hit a grand slam at trial or a hearing, they wouldn't even be able to achieve that with their offer. And so then I might say to them at the mediation, well, if you're going to give me that offer, you might expect that they might close their books and go home, because that's not a good faith offer, because you're coming with an offer you can't even achieve in your best dreams and hopes and hopes again at a trial. So you need to think about what your first offer is going to be, so you don't run into that problem. Because if the client thinks that that's a good strategy, they may be very surprised when they hear from the other side, listen, if they're going to not even play between the boundaries that they've set, then we're going to leave. And that might be very surprising to your client. So understand what your first offer could be. And also understand, as David was saying, I think, understand what you're fighting for. I typically at the mediations break it down at the beginning for parties separately, of course, not together, but separately, as to what they're fighting for. Like with a will challenge, sometimes one of the issues is there's a joint account, which should be an asset. Someone's alleging should be an asset in the estate, and it's worth $750,000. And the last will that's being challenged splits it 3 ways. And someone is saying, well, I'll settle the will challenge, but I want $750,000. But there's 3 residual beneficiaries. Well, if the will was valid, you couldn't get $750. You could get $250, because that's the residual amount if the count were to be included in the estate. So it's understanding what the fight is about for the respective client. And as a mediator, I dare say that that's what most mediators want to understand, is what are the two parties actually fighting about, so that you can try to bridge the gap about what the issues in dispute truly are. Okay. Now, you also want to think about, what does it look like at end of day if you resolve the matter? From a mediator perspective, you would like to have minutes of settlement signed. If there's going to be releases, which there almost always are, releases would be drafted. But you also need to understand your client and how long the day may go. It's often difficult for elderly people who are in their 70s and 80s to be on Zoom for 10, 12, 14 hours. So if you're settling and it's a question of doing your minutes of settlement, I am finding that in sort of the last 6 months, some people are saying, we'll do an agreement in principle, and that agreement in principle will have minutes of settlement to be done. This is what David's point is about drafting minutes of settlement. Because if you have draft minutes of settlement prepared, you don't know what the exact settlement's going to be, but you can have an idea as to what the preambles are going to be, what the style of cause is going to be. What are those 5 or 6 paragraphs that go into every settlement about you've had independent legal advice, the province of Ontario is the law, about counterparts, and have all the signature blocks, and maybe have some clauses you think might be in there. Then you're not looking at drafting minutes of settlement that would take 2 to 3 hours. They might take an hour. Well, that could allow your client to be able to be comfortable with hanging in on a Zoom mediation long enough to do the minutes of settlement. Okay, so that's an important factor. And when I'm counsel in a mediation, I typically have draft minutes of settlement with me and working on them during the day, so that it's not just a 5 or 6 o'clock thing going, oh, we need to do minutes of settlement. That's very helpful. But it's important to understand for you and your client that you mutually understand how the day might look at the end of the day, and if your client is tired, and how you're going to evidence the settlement. A couple commonalities of files that don't settle. In a will challenge, it's where people are alleging undue influence and lack of testamentary capacity, but they don't have the drafting lawyer's records, and they don't have medical records. And so I've had mediations where someone was alleging capacity, but they didn't get the medical records. And they're saying, well, you know, mom or dad were incapable. And I'll say, okay, but what is the evidence you're relying on? Like, what are you trying to convince the other side? And so I've had mediations that had to be adjourned for a couple of months to get those records, and then we come back for a second day. I actually had, I think, 3 or 4 mediations last year where we didn't settle on the first day. Parties got close or within the parameters of what looked to be like a resolution, and then everybody agreed we'll come back. In one case, we came back in 10 days. Another case, we came back within 3 months because they wanted to go get some tax information and some accounting information, and then they came back. And in all those instances, they settled on the second day. So going into the mediation, depending on how complex it is, how many parties there are, have in the back of your mind that if it gets close to resolution, but it's not quite there, would you be willing to go to a second day of mediation? And I'll leave it at that. Oh, and the other aspect that David mentioned is about taxes and financial information. Mediations can fall apart because the parties haven't turned their minds to what the tax consequences are. And as David said, parties think that you're dealing with a pool of $1 million, but they haven't factored in capital gains, and maybe the capital gains are 1/4. I mean, the payment for the capital gains is 1/4, so you're dealing with $750,000, not $1 million. So given our time constraints, I will leave it there and leave it open for questions.
Thank you very much, Craig. Thank you, James. Thank you, David. That was a fantastic presentation, really helpful. We've got one question in the chat. You know, this is a really helpful question here. It's talking about third parties at a mediation. So think about maybe the daughter of, you know, one of the parties, could be an elderly mom, daughter's helping them out, attending as a third party. So the question is, the specific person's concerned about privileged information. When third parties are attending the mediation session, will the confidentiality clause or a non-disclosure agreement signed by those third parties protect the client and protect that privileged information?
Well, that's why I said earlier in my presentation, everybody who participates signs the agreement to mediate. And the agreement to mediate specifically lays out confidentiality provisions. So that's a contract, right? And so that non-party has agreed that in exchange for their participation in the mediation, which is consented to by the other parties, they are bound by the confidentiality provisions. I will not proceed with a mediation if someone wants to participate and they won't sign the agreement to mediate. I've had it in person where someone showed up, they were a spouse, and they said, I want to participate, and but I'm not going to sign the agreement. And I said, well, then you can leave the building because you are not going to participate in the mediation, and you can tell the lawyer and your wife why the mediation is not going to go ahead today if you're not going to remove yourself from the premises. So that quickly rectifies the situation, because then the lawyer who's representing the wife has a significant issue. They're either going to allow the spouse to crater the mediation, or we proceed and the spouse will leave. I've not had it in the end where someone didn't sign an agreement to mediate. If you're firm and polite and diplomatic, it usually can be worked out.
Thanks, Craig. I see Charles Wagner has his virtual hand up. Go ahead, Charles.
First of all, I want to compliment the presenters. I thought you guys did a great job. I have a question for the three of you, and I'd like to set it out in a hypothetical. You have let's say Jandy John from Concentra appointed as the ETDL. You need information that she was going to collect in order to properly settle this thing. I'd like to hear from the mediator's perspective and the lawyer's perspective, what are your protocols for dealing with the ETDL and making sure that they've done their job and gotten you the information?
I mean, I'll leave it for David and James, but I will say this as a mediator, that should be done before the mediation. So from a mediator's perspective, I'm anticipating that the parties will have the information, whatever it is, that they would need beforehand. Now, as a mediator, I might say to one of the parties, hey, this is a potential hurdle to a resolution. So, it would be having Jandy or someone from her office available during the day if they're not participating in the mediation, so as to be able to provide information should something come up. But it should be, if there's information to be obtained, it really should be the parties prior to the mediation.
But you raised something else that before David and James address this, it's of real interest to me. Often the mediation minutes call on the ETDL to do stuff, and they've got to agree to do it. How do you arrange for that if they're not at the mediation?
Okay, so I'll give you an example. Let's say that the parties are able to come to a will challenge resolution, and let's say it's an institutional estate trustee during litigation, and the parties want an accounting before they just, deal with the discharge of the ETDL and the appointment of an estate trustee. What could be done, and I have been involved in this scenario before, is you build into the settlement that the ETDL will be asked for an informal accounting of their accounting, which if it's an institutional one is typically easy to provide because they just provide the statements, the monthly statements or the quarterly statements. If the parties are satisfied with that accounting, then they might agree that the ETDL gets discharged and that ETDL will be appointed as the estate trustee. The parties can agree that there's going to be the appointment of an estate trustee vis-a-vis the new will. And then they build in provisions into the settlement as to how they can deal with the ETDL, allowing the ETDL to provide an accounting, have that consented to, or perhaps if it's not consented to, but put that process in place, and then allow for the ETDL the opportunity, if the parties wish, to become the ET, but not make it mandatory. So in the case that I just said, you could say, if the ETDL's informal accounting is acceptable, the parties agree to discharge the ETDL and agree to appoint the ETDL as the estate trustee. In the event that the estate trustee during litigation does not accept that appointment, the parties agree that they will agree upon a mutually agreeable individual or trust company to appoint. And then you say in your minutes of settlement, all of this will be part and parcel of an order of the court. And so that's a way of dealing with the discharge. It's a way of dealing with the appointment, and it's a way of allowing the ETDL, if the parties want this, to become the ET, but not constraining the settlement itself. Sorry, I guess I took the answer, James and David, on that one, but.
No, that's okay. But the reason that Craig has such a great answer is because him and I just dealt with this exact scenario at a mediation as opposing counsel. And that's exactly what the minutes of settlement that we arrived at looked like. I won't tell you which one of us drafted it, but that's exactly what it looked like. So I do like to have whoever is acting as ETDL on notice that the mediation is happening and available in case there are questions asked, because inevitably there's clarification with respect to the current value of assets or something along those lines. But in an ideal world, I'd also like their input on the minutes of settlement that day. It's not always possible. In fact, most of the time it's not possible. So you have to come up with practical workarounds like something that Craig described. But ultimately, if you are including provisions that affect the ETDL in the minutes of settlement, you have to get their consent. So as an example, what I've seen when I've represented the ETDL, and I haven't participated in the mediation, is you see minutes of settlement that call for distributions from the estate within X number of days. Now, an ETDL cannot make a distribution of the residue of the estate under the legislation. It's just not permissible. Somehow courts will order ETDLs to make distributions, notwithstanding that provision, but you need a court order to do it. The ETDL just cannot make a distribution and cannot be compelled to make an interim distribution. It may not be advisable for an ETDL to do that from a tax perspective, let's say. So if you want to include something like that, you have to make sure that you get the ETDL sign off in advance, because that can upset a settlement. You know, person A thinks that they're getting $350,000 within 30 days, and that may not be possible, not because of the opposing party, but because the ETDL cannot facilitate that payment in that time frame. So you want to be cautious about it.
And I would say too, as an add-on with respect to mediation, I certainly suggest prior to the mediation, considering what orders you may need from the court arising from a resolution obtained on that day. For example, will it be necessary for the inclusion of a provision that a certain will is the last valid and binding will of the deceased? As we've just mentioned, provisions regarding the ETDL, provisions regarding the estate trustee, provisions regarding the assets. Is there going to be a sale of a property before a certificate of appointment will be obtained? Is that something that the parties might seek from a court? These kinds of orders are sometimes more difficult to think of if it's 7 or 8 o'clock at night and you're trying to finish off a mediation versus thinking of it beforehand and coming in with a list of possible draft, or like just a line, a bullet point. Don't forget about appointment. Don't forget about naming or declaring which of the wills is valid. Don't forget that. And so if you have that little list, then when you're trying to finalize the terms, you might not actually draft the draft order, but you can think about what kinds of provisions would be included in that order to be obtained from the court.
Great. All right. Well, thank you all for that. I see that there's a couple hands that are raised. I'll start. I see Jason and Mukta both have questions. So let's start with Jason's question and then we'll go to Mukta.
Thank you, Peter. I had actually a question for James. I know Craig touched upon this earlier when he was discussing, excuse me. Sorry about that. When he was discussing in-person mediation versus virtual mediation, I was wondering if there's any beneficiary that doesn't reside in Canada but wants to participate and get involved in the mediation, if there's any special considerations you should make for international beneficiaries in the state mediation context.
Sure. So building on what Craig said, they'll have to sign the mediation agreement, and the mediator should ensure that that's done. But from a settlement perspective, there's certainly special considerations, not only for the non-resident beneficiary, but also for the estate trustee. So when estate trustees make distributions to non-resident beneficiaries, there are some special requirements. You should know that the Income Tax Act deems a distribution to a non-resident beneficiary to be a disposition by the non-resident of a capital interest in a trust. And that's a taxable event. And Canadian executors, they're required to withhold, I think it's 25% as the applicable tax and remit that to Revenue Canada. Or the non-resident beneficiary must go and apply for and obtain a Section 116 certificate. And that's a certificate of clearance. Now, the good news is that there's often very little actual taxes payable once the form is submitted. I can't remember the name of the form, but the actual taxes are often significantly less, and sometimes no taxes payable at all. but the requirement to apply for and obtain the Section 116 certificate does not change. And it's super important to remember that when you're crafting minutes of settlement, and to build that in. And it's a simple, distribution shall be made to X non-resident beneficiary upon the obtaining of a Section 116 certificate and presenting to the executor, something like that.
Thank you, James.
Look, to go ahead, I see that your hand's up.
Thank you, Peter. My question is for Craig. What are some strategies to prevent an unrepresented beneficiary at a mediation from blowing up a settlement agreement between represented parties?
I think a couple of things, and it starts prior to the mediation. I think ensuring that there's ample opportunity to provide a brief, and that the unrepresented party can be, and I use this word very loosely, assisted in saying that, somebody can tell them, one of the parties can tell them that they should be doing a statement of issues, laying out what their issues are. I did a mediation which had 7 unrepresented parties and had 1 represented party, which was an institutional estate trustee. And we had 2 case conferences, certainly with the consent and at the request of the institutional estate trustee. So all the unrepresented were on, and there was a pre-mediation discussion about providing a statement of issues, and if they had any documents that were relevant, providing those documents and giving ample time for them to file that. The estate trustee requested that because they knew that having 7 siblings, and none of them wanted to spend money on legal fees. And so in the end, that process worked, and we had a resolution at the end of the day. A couple of things that you can do is make the settlement conditional on on bringing a motion to the court on notice to the unrepresented person in respect to the settlement. I'm not saying which of these is appropriate for a specific instance. The council will have to decide that, but I've seen it where the parties who did settle brought a motion or said they were going to bring a motion on notice to the other parties who were unrepresented, who participated but wouldn't go along with the settlement, offering that the unrepresented person get ILA. I've seen it in mediations where that ILA was agreed to be paid for by, say, the estate, with a stipulation that the ILA be reasonable in terms of its quantum. It's also important to think about, how are you going to get an unrepresented person to sign minutes of settlement? Okay, because some of them won't have scanning abilities. In the case of the unrepresented, the 7 unrepresented I had in one mediation, 4 of them had scanners, 3 did not. We settled even the written documentation at 9 o'clock at night. Well, you want everybody's signature if you can, or at least an acknowledgement of signature. So what we did was, we had shared the minutes of settlement with everybody. It was by Zoom, so we did it on the screen. Every provision was gone through. Everybody had a chance to comment on a provision, and when was it agreed to, we said, okay, the next one. Then, because 3 of them couldn't actually sign the document that day and get it back to people because they didn't have a scanner, what was agreed upon was an email came from me with agreed upon language that went out to everybody, that had a copy of the minutes of settlement that had been just gone through, and it said something like this: I acknowledge receiving the attached minutes of settlement. I acknowledge that all the parties went through the terms of the minutes of settlement. I acknowledge and agree to the terms of the minutes of settlement. I acknowledge and agree that this email shall suffice as my signature for the purposes of today for the minutes of settlement, and that I undertake to provide a written copy of the minutes of settlement with my signature within blank number of days. Everybody signed that. Or everybody, sorry, it was sent to everybody. Everybody acknowledged that by way of an email. And then the next couple of days, people, I understand, exchanged the minutes of settlement with their signatures. So as a mediator and as a counsel who may be involved with unrepresented parties, you do need to think about how are you going to affect something? How are you going to mechanically do something? And it's not uncommon for elderly people or younger people not to necessarily have a scanner in their house. Sometimes people take pictures with their phone and then send it to everybody. You know, that can be done. Will you allow DocuSign to be used? Maybe a party has the ability to allow DocuSign for the minutes of settlement, and then it's sent to everybody so that an unrepresented could sign it that way. These are all things that council can think about beforehand, but they are actually real considerations.
Awesome. Great question. Fantastic answer. Thank you so much. Thanks again, everybody, for presenting. Thank you all that attended today. I know we're past time, so thanks for sticking around. Our next seminar on will challenges will be about focusing on the family law context. Really helpful for those interested in family law and those family lawyers out there. That seminar will take place 2 weeks from now on September 20th, again at 12 p.m. By Zoom. So we all hope to see you there, and have a great weekend, or have a great week. Take care.